After looking through the anti-SLAPP motions filed by Evan Rachel Wood and Ilma Gore against Brian Warner, professionally known as Marilyn Manson, I'm not entirely certain that filing those motions was a good idea, given the options that they had in responding to the complaint. Let's get into it. Hey everyone, welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. So to begin, when the complaint is filed by a plaintiff, the defendant in the case can have several options in responding to that complaint. They can file an answer, which basically goes through and admits or denies the various allegations made in the complaint. They can file a motion to dismiss the action, or in California court, it's called a demurrer, or they can file a motion to strike one or more claims within the action without attacking the lawsuit as a whole. And in California, under certain circumstances, they can also file a special motion to strike, also known as an anti-SLAPP motion. Some defense attorneys operate with the philosophy that the defense should take every single opportunity to dismiss as many claims as possible as early as possible. This would mean filing a motion to dismiss to duke it out with the plaintiff right from the outset, making the plaintiff's task of proving their case all the more difficult. But there's another litigation philosophy that says that sometimes by forcing the fight early, all you do is create an advantage for the plaintiff, either by giving them the opportunity to sharpen up their allegations to prevent dismissal or some other unforeseen advantage. Now, to be clear, the anti-SLAPP motion is a very powerful tool in the litigation process, particularly in California. The reason for that is that it's designed to protect the defendant from litigation that is designed not to actually right a particular wrong, but rather just to prevent the defendant or to punish the defendant from exercising their First Amendment rights to free speech or to petition their government, oftentimes through the litigation process. As an example of the strength of the anti-SLAPP motion, as soon as it's filed, several things happen. First, the anti-SLAPP motion filing freezes discovery. It prevents any sort of exchange of information between the two parties. The plaintiff cannot request any sort of documents or information or depositions from the other side as soon as this motion is filed. Otherwise, with a normal answer or motion to dismiss, the plaintiff would still have the ability to request this kind of information. The second thing that it does is it prevents the complaint from being amended. In other words, the plaintiff can't look at the complaint, realize that they've made some mistakes, and just amend the complaint on their own. If they do, there is a possibility of penalties for them to pay to the defendant in the process. And third, it also prevents the plaintiff from voluntarily dismissing their case. They can't decide, whoops, I shouldn't have filed this, and then quietly dismiss their case without repercussion. If they do that, there's also a possibility of incurring penalties from the other side. And if the defendant can successfully make their argument, it can result in a total dismissal of the case, and they can get their reasonable attorney's fees paid for by the plaintiff. So why do I say that there is a risk if anti-SLAPP is such a powerful tool? Let me contextualize to explain. So I won't go too far into detail about what an anti-SLAPP motion is in this particular video or what the legal standard is for an anti-SLAPP motion, because if you've been following the content on this channel, you probably have heard me talk about it many times at this point, and you probably don't want to hear me go over that again and again and again. But if you haven't, or if you're unfamiliar with the arguments made in these particular anti-SLAPP motions, there is a link in the description below and on the screen here to my latest deep dive live stream on that particular subject. But what I will say here is that the anti-SLAPP argument in California consists of a two-prong test. The way I like to describe it is it's like a game of hot potato. In the first prong, the defendant has the burden of making a showing, and in the second prong, the burden shifts over to the plaintiff. Whichever side fails to meet their burden loses. So what does the defendant need to happen in these two prongs in order to win and to dismiss the claim? Well, In the first prong, the defendant has to show that the conduct underlying the plaintiff's cause of action, or portions of the cause of action, arises from the defendant's constitutional right of free speech or petition. This means not just speech, but also conduct that helps to advance or to assist that speech. Anything that is said in a congressional hearing or to a legislative, executive, or judicial body for some kind of official proceeding is going to fall under this prong. The same thing goes for speech that falls under the definition of a public issue or an issue of public interest, or conduct that helps to support that activity, such as news gathering for the purposes of reporting on the news. Now, in the second prong, as I said, the burden shifts over to the plaintiff to make a showing that their claims can survive. Otherwise, the defendant will win and the claims at issue in the motion can get dismissed. So to prevent that, the plaintiff really has to show two basic things. First, they have to show that they have a legally sufficient claim. This means that they have to show that they've alleged enough to plausibly state a claim so that the defendant is on notice for what they need to defend against in the litigation. Second, the plaintiff has to show that there's a probability that he'll prevail on the claim. And because he's a public figure, he has to show for both his claims for defamation and IIED, or intentional infliction of emotional distress, that the defendant was acting with actual malice, and he has to show it with clear and convincing evidence. And now, just in case you've somehow forgotten, if you're a regular viewer of this channel, when we say that the defendant acted with actual malice, we're saying that they made a false statement, either knowing that what they said was false or with reckless disregard as to the truth or the falsity of the statement. And to show actual malice with clear and convincing evidence, it can't be just more likely than not that the defendant acted with actual malice. It has to be clear to an objective viewer without hesitation as to what's happening here. And now to do all of that, he has to use admissible evidence. Now, to be clear, Brian Warner's public figure status does elevate the burden he has to prevent the anti-SLAPP motion from succeeding. But don't be fooled. At this stage, in order to defeat the defendant's motions, he doesn't need to show with clear and convincing evidence that they acted with actual malice. That is something that is reserved for a later stage in the litigation, particularly at the trial stage. Instead, he has to show that he has a reasonable probability of proving with clear and convincing evidence that their conduct was made with actual malice. In other words, he's not expected to make his entire case at this stage, just to convince the judge that he can do it later in the litigation. And while we haven't seen his opposition papers to these anti-SLAPP motions yet, from what I've seen of Evan Rachel Wood's and Ilma Gore's arguments as to this particular prong, I'm not entirely convinced of their arguments. And so here's why I think that this is such a risk for Evan Rachel Wood and Ilma Gore. Of course, as is the case with many of the cases that we cover on this channel, the parties involved in this case are battling with each other in two courts at the same time, the court of law and the court of public opinion. Now, if they win the anti-SLAPP motions, Evan Rachel Wood and Ilma Gore will have managed to dismiss Brian Warner's strongest claims at the outset of the litigation, effectively, in my opinion, at least gutting the majority of his case. But if Wood and Gore lose on these motions, several things will have resulted. First, if they lose, it will be because the court has found that Warner has a probability of proving his IIED and defamation claims, and that they were acting with actual malice, with clear and convincing evidence. This means he would pass an early, rigorous test to show how likely it is that he might actually be able to win this case. And the court would be signaling here that he most definitely has some sort of a case. Second, if Wood and Gore lose, they'll have just given Warner the opportunity to put forth his best arguments and show some of his cards as to what he has evidence-wise for his claims. Normally, the opposing party finds that out during the discovery process, which is generally outside the public eye, unless documents or videos, what have you, get leaked to the press, of course. But in this case, Warner has to make a showing in response to the anti-SLAPP motions, and those arguments have to be filed, and the public has access to those filings unless some portions of it are filed under seal, of course. But filings under seal notwithstanding, at the same time that the defendants would be finding out a bit of what cards Warner has here, so is the public, many of whom are highly skeptical of the merits of his case at this point, even among people who strongly support Johnny Depp versus Amber Heard. And in making his case here, he also may be able to put out enough evidence at an early stage of the litigation to start to convince more people to stand with him as opposed to Evan Rachel Wood. This ultimately has implications not just in the court of law, but also in the court of public opinion. Whether or not this is all good or bad is up to perspective. For me personally, I admit that I am very curious to see what kinds of arguments Warner will have to oppose the motions. For me, it might be convincing, it might not yet. But what do you think? Do you see this as a cause for concern? Are you more curious about what evidence Warner will be able to show to make his case? Do you support Evan Rachel Wood and Ilma Gore? Do you support Brian Warner, aka Marilyn Manson? Let us know in the comments down below. Otherwise, I hope you found this interesting or at least informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you haven't done so already, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. See you in the next video.